Okay, well, I think we're all here, so thank you very much. It's 10 o'clock, just about. Let's open. I wanted to start in a bit of an odd place, which is genuinely to thank everyone for their contributions and effort. We really do appreciate the amount of effort that everyone has put in, that goes into a local plan examination, the strain that it puts on the council and others, of course. So everyone's work is genuinely very much appreciated. So it's 10 o'clock. That's all right. Good. That's reassuring. I'm Tom Bristow, jointly appointed with Matt Birkinshaw, who's not here today, to examine the Dacorum local plan and also the St Albans local plan. We've got Louise and John Howe in the corner, who deals with anything to do with the running of the examination. Now, there are many familiar faces, or I'm certain if you're not a familiar face, you're well aware of proceedings. So I will keep introductions to a minimum. Just a couple of points. Please keep your phones on aircraft mode. Don't hotspot off them, as that interferes with the microphones from time to time, but everything's worked very well when that's been adhered to. If you do need to get on the internet, there is the code, there is the password on little sheets of paper around the place. The microphones are important so that we are tracked in terms of the video live stream and the recording, so please do use them. Right-hand button to come in, right-hand button to turn off. They do take occasionally a little bit of time to warm up. So, as we do in these sessions, if I could turn first to the council, Mr. Layden. I'm conscious I'm sitting in a bit of a different place, but any emergency procedures, anything we need to be aware of from your perspective? Thank you.
Thank you, sir. Good morning, everyone. So with regards to emergency procedures, just to confirm, we're not expecting a fire alarm test today. Within the council chamber, the fire evacuation alarm is a combination of a voice alarm system and a traditional siren. Outside of the chamber, it is just a voice alarm system. The alarm will announce that the building must be evacuated due to an emergency. On hearing the fire alarm, everybody must immediately leave the building by the nearest available route. There is a staircase on the right as you leave the council chamber, or to the left and past the lifts as an alternative option. Please follow a fire marshal. If in the event of a fire you would need assistance in using the stairs, please make reception aware. The main assembly point is at the Market Square. For those who are not aware, it is just outside them. If you leave the council offices by the main entrance exit and cross the pedestrian lights crossing, a short walk along the high street will get you to the Market Square. Toilets are located to the left after the lifts and also by the cafe on the ground floor. As has been mentioned, the hearings today are being live streamed and recorded to be made available after the session. Please be aware and leave the council chamber if you do not wish to be filmed. Thank you.
Okay, thank you very much. So technically, we're in a reserved session today, but thematically, this is to address question 7 in our matters, issues and questions in respect of plan allocation HM11, land at Shendish Manor and Fairfields, which we were unable to progress through on the 4th of March. And that's very much the running order for today. It's only that issue and, of course, things, and I'm looking in Councillor Anderson's direction, that are inextricably linked to it. For example, strategic alternative natural green space, or SANG, and the relationship there. So thank you all for approaching today with that context in mind. There are a handful of administrative or programming points, timing points that I think will be useful we deal with as well at the tail end of the session. Those aren't specific to HM11, those are general points to do with the local plan examination, given this is effectively, as programmed, the last hearing session. But those are relatively few and will break before that. So you don't have to stay, but you're very welcome, of course, to stay if you want to hear those. I think before I introduce the sort of context to what we're here to discuss, and where our particular focus is. If we can just quickly go around the table and introduce ourselves. Now, I know we're all here for HM11, so there's no need to particularly say your perspective on HM11. And we have almost an inquiry set up here with the council, the promoters, and those who are in objection to this element of the scheme. So, starting with you, Mr. Layden, if we just introduce ourselves, that'd be useful.
Thank you, sir. Yes, my name is Ron Layden. I'm Head of Strategic Planning here at Dacorum, overseeing the new local plan. I'm accompanied on my right by Mr. Craig Howell-Williams, King's Counsel, Francis Taylor Buildings, representing Dacorum, and to my left, Ms. Keely Mitchell, who is Principal Planning Officer in the team.
Mr.
Good morning. I'm Nick Grant, Counsel, here on behalf of W. Lamb, accompanied on my right by Mr. Will Swan of Swan Golf Design, from whom you'll have seen some notes, and to my left by Miss Alison Jones of Boyer Planning, from whom you'll have also seen some notes. Thank you.
Good morning, sir. I'm Councillor Alan Anderson. I represent King's Langley Dacorum Borough Council. I'm leading the objections in this case. Immediately to my left is Mr. Chris Preshaw, who's representing CPRE Hearts and King's Langley Parish Council and local residents, I believe. To his left is Mr. Chris Burton, who is the former or incoming captain of Shendish Manor Golf Club. And to his left is Mr. John Nichols, who's alternately incoming or outgoing captain of Shendish Manor Golf Club. For the last 6 years.
Noted. Thank you, Mr. Nichols.
I'm not aware of.
Yes, good morning, sir. My name is Roy Warren. I'm Planning Manager at Sport England. I lead Sport England's planning work in this part of the country.
Thank you very much. Okay. Thank you. That's useful. Good. That's a good cast list. Now, the reason we didn't get onto this session on the 4th of March is there was an email from Sport England / England Golf that in alphanumeric code is ED49, examination document 49 as I have it, and that landed on the morning of that session. Now, I think it's just useful to go through that and to go through what the latest state of play is, no pun intended. That email appeared to effectively reinstate Sport England's former objection to HM11 on the grounds of loss of sport provision or part of the golf course. Now, I'm just going to say that that correspondence was somewhat equivocal. It appeared simultaneously to say that the loss of part of the golf course is not justified, but then on the other hand, it suggested that a main modification might be a logical outcome if we were to support the allocation. Now, we had the consultation that ran from the 5th of March to the 18th of March, and there were several responses to that, 9, I think, in total, excluding commentary from the council. I've reviewed all those responses, including from objectors, promoter, the council. I would say that many of them are very highly detailed, informative, useful for us in terms of what they set out. All those can be taken as read, and I don't want anyone to sort of repeat or present parts of those because we're very well aware of those issues, and thank you for those. Insofar as, well, what's our role, this specific issue is concerned, question 7, HM11, it might be useful to have the December version of the National Planning Policy Framework open. Paragraph 103C is perhaps worth just reading that out, because that is effectively the sort of guiding principle in terms of our consideration. So 103C of the NPPF says, and I'm just going to read it out, existing open space, sports and recreation buildings and land, including playing fields, should not be built on unless, then we've got A, B or C, and C appears to be the key one here. The development is for alternative sports and recreation provision, the benefits of which clearly outweigh the loss of the current or former use. And so that is consistency with national policy is a test of soundness, and that's what we are looking at. So there are a few themes that, if they don't come up sort of naturally in conversation, I want to explore. But before we do, appended to the council's comments in relation to that consultation on the email of 4th of March from Sport England, and I trust everyone's seen this, there is further correspondence of the 11th of March, which I trust everyone has seen as well. And that provides more detail on Sport England's position on options A and B, as in Mr. Swan's or golf feasibility study. And I would just read an element of that out, as effectively I'm making sure you're all aware of the information that we have and that everyone's seen it. And that says, in particular, I would wish to clarify that England Golf or Sport England would not require an 18-hole standard length golf course to be retained or replaced within the site to be supportive of the proposals, although there would, in our view, be clearly sufficient demand to maintain an 18-hole standard length golf course on the site. So that says two things. Firstly, that, and I think this comes out, I'm trying to look, is it Mr. Nichols' hearing statement that talks about the viability of an 18-hole golf course. So clearly that says, well, in Sport England's view, that remains viable, and I'm sure that will be echoed by various people. But what that also says is it appears to retract, if you like, the position of the 4th of March email saying that there was an objection inherently to the loss of an 18-hole golf course. That position, it appears, is contingent on a few things, and I'm saying this so anyone can correct me if I'm wrong. Demonstrating the feasibility of any alternative. So at the moment, from Sport England's perspective, they're not satisfied that has been demonstrated, including in respect of SAN, Strategic Alternative Natural Green Space, which may, as Councillor Anderson points out, have implications for either site capacity or the relationship with Shendish Manor listed building itself. Now, as I have it, there is a main modification that has been suggested. So main modifications are ones that we can recommend to make the plan sound, which in short is described as part 4 of the policy, would therefore need to be amended to ensure that the mitigation package outlined above, and there's a lot of detail of consideration of different elements, I think it's of options A and B in the golf feasibility study, was delivered as a minimum rather than an option. So maybe it's to turn to Sport England initially, and sorry, I should have said, if you do want to speak, just tip your nameplate on the side. Maybe I'll turn to Sport England first to see whether my understanding of their position is correct. I'll turn to the council to see what they think of that suggested main modification. And then I'll come on to, well, whether others agree with it or not. I think that's the fair way of doing it. So, Mr. Warren, can I come to you first?
Yes, thank you, sir. Just to clarify the position, we've always said that we're willing to consider alternatives to retaining an 18-hole standard golf course. So we've not objected in principle to the loss of 18 holes. What we've always said, though, is that we would only support an alternative if it met the requirements of paragraph 103C. And to date, it hasn't been demonstrated to our satisfaction that a mitigation package which could meet the requirements of paragraph 103C can be met. In the most recent correspondence that you referred to, we set out a number of requirements which you've summarised, which basically said we want it to be demonstrated indicatively that the package that we were seeking, the 9-hole standard golf course, full-length driving range, adventure golf and so on, could be provided without compromising the other requirements of HM11 policy, particularly the requirement for the on-site staying, residential capacity. Because based on our experience, if this is not demonstrated at this stage, at the planning application stage, if there's competing land uses and choices have to be made between residential capacity, SANGs and golf mitigation, I would be concerned that golf mitigation would be, let's say, the one that would be compromised. So we said that we would need it to be demonstrated before we could review our position on that. If it could be demonstrated through indicative feasibility that all those facilities could in principle be provided. And there's a minimum requirement in an amended policy to ensure those facilities provided. It will be our view, based on England Golf's advice, that the balance in paragraph 103C could be met. So we've just emphasised, we've not said it's got to be 18 holes, but we're providing advice as a, obviously as a government agency. We are impartial. We don't use the golf course. We haven't got the local knowledge. So, it's really important that the views of the golf club committee and others who've got a local understanding of the operation of the facility are also given due weight as well. But hopefully, does that explain our position?
That is clear. Just one point that perhaps wasn't. In your view, is it that in order that we would say we were going to find, in the hypothetical world, we were going to find HM11, that allocation justified, we would need, from your perspective, or would we not, to see that feasibility study, to see that, to have satisfaction from your perspective that was there? So actually, from your perspective, can we find it sound subject to a main modification? I just want to be absolutely clear on that. At this juncture, what's your position there?
As I said in my correspondence, we would need that feasibility now, not at a later date. Because if the policy was amended to require that later date, I've yet to be convinced that there's enough space on the site to accommodate the mitigation that meet para 103C without compromising the policy. So our position as it stands would be an objection.
Ms. Mitchell.
Thank you, sir. One thing I'll point back to before I turn to our response, we've also agreed an addendum to the Statement of Common Ground with Sport England, so that's examination reference ED 48A. Sets out the background from the fact that we had a meeting on the 9th, we got the email on the 11th, that confirms the latest position. I shared that with the site promoter. I point out the matters in which the parties agree, so that's paragraphs 3.1 to 3.3, that statement of common ground. Is that working okay? You guys can all hear me fine?
I'm getting a bit of distortion, but yeah, I can
follow
it. Keep going, we'll see how we go.
Yeah, let me know. So we agreed in principle that a mitigation solution could be delivered on this site, subject to further detailed design and feasibility, that neither Sport England or England Golf would require the retention or replacement of an 18-hole standard length golf course for them to support the proposals. And then paragraph 3.3, we agreed to the principle that the golf investment strategy should be agreed prior to the determination of a planning application. In our response to the consultation on ED 49, we set out that we don't consider it to be effective to set out the minimum requirements within the policy, because this would be overly restrictive. We also raised some concerns with the justification of some of the specific points, but ultimately we consider that this could be resolved through further discussions as part of the ongoing pre-application, but as part of the plan, it wouldn't be necessary for soundness to include those as a minimum requirement, and that we believe the modification suggested within the original statement of common ground, so that's ED 48, would be sufficient.
So not to put words into your mouth, but your view, is it your view that subject to a suitably worded main modification, there would be nothing to prevent HM11 being found by us as justified as an allocation, subject to reflecting, it seems like, MPPF paragraph 103C, those provisions, rather than perhaps going as far as Sport England would suggest in terms of outlining what that particular strategy would be?
That's correct, sir. I would say the proposed modifications to the social and community site-specific requirements of policy HM11 So that's point 4 and 5. I know we referred to point 4 earlier, would be sufficient to ensure that the golf investment strategy or feasibility prepared and agreed as prior to the determination of the planning application would be sufficient enough to ensure that that study identifies mitigation in a manner consistent with the National Planning Policy Framework, whilst allowing that flexibility at the planning application stage.
So then you don't buy necessarily Mr. Warren's argument that it's necessary to specify that up front?
We believe that further detailed evidence may demonstrate why alternative provision or different alternative provision could respond more effectively to the issues that have been identified. So we, again, in my response, I set out some comments about the indicator used. The regular golf demand indicator sets a benchmark against a national average provision. However, within our playing pitch strategy, which is HEA 05.1, we recognise that if golf courses are identified for future development, there should be a full needs assessment. So this benchmark indicator is highly strategic in its nature. It's limited by a lack of consideration of local factors, including financial viability, capacity, etc. So it shouldn't be the only indicator that is used. We request a full needs assessment or identify the need for that as part of the evidence, which is something the site promoter had prepared. I think it's Appendix 4 of their hearing statements, but it was prepared at an earlier stage. It's just the easiest point of reference between documents. I point to their hearing statement, and that identifies demand arising in the area for beginner and casual players.
So if I can, without prolonging it before I bring people in, if I can, sort of a devil's advocate question, really. If there is some sort of main modification, as the council have suggested, tying HM11 to NPPF paragraph 103C, in the absence of a study that satisfies you at this stage, and then what comes forward doesn't meet that, presumably planning permission would be refused. Ooh. So I don't know if that's a question for, so effectively, is it not, if you like, the promoter's risk to meet that criterion that the council thinks is correct? Obviously, you'd have a role in terms of saying whether that had been met. I can't quite, I just want to establish whether that would be correct, why there's the necessity to have that now, if that makes any sense, Mr. Warren.
Thank you. I mean, the reason we're pushing for it now is because this is when the suitability of the allocation has been determined. And if you play out a hypothetical scenario, let's say the modifications accepted, the allocations found sound, planning application is submitted for the golf mitigation, it doesn't meet what we would expect it to, in terms of meeting paragraph 103C. Yes, we could object to the planning application, but the wording of the modification, it could be interpreted, well, the local authority can take that judgment of the benefits and impacts. From our point of view, we say we'd need that minimum requirement now to provide the certainty that that balance in 103C could be met. Otherwise, it's open to interpretation. And obviously, as the allocation has been promoted by the council, I'd be surprised if we got to a planning application, we objected as a non-statutory constitute, which would be on this case. And if we did object, I would expect, if that mitigation package wasn't something we'd support, that it's likely, obviously I can't give certainty, it's likely that the application would approve with a potential mitigation package which didn't meet that balance, which is why I need the comfort now that that as a minimum requirement.
Yeah, I'm maybe deliberately being a bit silly on this one. But if there is a requirement there, that there is a replacement, sorry, not a replacement, a different strategy that accords with NPPF paragraph 103C, and that isn't met, surely in terms of what is written on the page, that application would be refused. I can't quite follow your logic that, well, probably it would still be. The one thing I can see is potentially the parameters of the other elements of the site, say, for example, in terms of the number of homes, in terms of the SANG, okay, there may be implications there if there needs to be kind of more land given over to whatever the alternative provision is. But we have an allocation that's for around 500 homes, so it could be fewer. I'm just putting the, if you like, the sort of counter argument. And we have, in terms of SANG, I'm just looking where the provisions are. Deliver, yeah, they're in biodiversity, green infrastructure, criterion 5, deliver suitable SANG to offset potential adverse effects. So it doesn't specify a particular quantity. So what I'm pushing you on is, why is it necessary at this stage, really? Thank you.
Yeah, I think it's because paragraph 103C is quite difficult because it's a subjective assessment and different parties could undertake that assessment and get to different views, which is why we're seeking that minimum provision to be defined in policy, so we don't have that subjective debate at the planning application stage. And so this is based on sort of many years' experience, not just golf courses, but a whole range of sports facilities applying that policy criterion. Whereas I think if we had the certainty of the minimum requirements and the feasibility demonstrating it, would give us the comfort that we got to planning application that the 103C can be met. Without that, it's open to interpretation. And so I'm just basing on experience. I would, given the constraints of the SANG and the residential capacity, I'm not saying that it's impossible to provide it, but it could be challenging.
Okay. Now, yes, Councillor Anderson, thank you for your patience. Let's hear from you. Yeah.
Thank you. Good morning, sir, again. I understand that the goal here is to try and solve the problems. Fully understand that. I have looked at this from the other side, as it were. But the amount of goalpost moving that's going on, or should I say goal flag moving that's going on, has meant that there have been lots of changes and lots of uncertainty and lots of last-minute documentation with, I think, 174-page report being produced literally days ago, and a lot of emphasis being played on the vague, undefined negotiations and the scope of whether they could succeed or not. It's the tenet of our argument that these issues are unreliable, and if that's the case, the scheme is undeliverable. And that's a key point, but there are some things that one can be sure about, and that is land availability and viability. And in both, in our written submissions, we pointed out, or certainly I've pointed out, that the land just is not there to comply with legislative requirements. And the gentleman to my left have written some very extensive, informed documentation about the viability. It's my view that the mitigation conditions clearly could not be met. As reading some of the documentation that's been produced in the last few days, even the promoter has said they just could not meet those mitigation conditions. So clearly the Sports England objection still stands. And I have to agree and support with the comment we've just heard from Sport England that the details can't be sorted at the application stage. Once they're in the plan on the current promoter's terms, it would be extremely impossible for the council to sustain a refusal of planning permission. Because ultimately, if it's gone through the test with the planning inspector here, it sets a precedent for a future test of the planning inspectorate. The other point I wanted to make briefly was the council's leisure strategy. I may have speed read it too fast, but I don't remember it saying that there's too much full-length golf facilities in the borough and there's no entry level, which would support what's being promoted here. And I would make the practical point that there's not much point in having an entry-level facility if you then don't have a quality full-length course for people to move up to in due course.
that was what I think the plain pitch strategy 2019 was one of the points I wanted to come. Is that the same as the leisure strategy? Just as
That was what I was referring to, yeah.
that was one point I wanted to come on to as effectively an input, but I will come to the promoters now just to get their view at this stage. That was one point I wanted to come on to. So yes, I suppose Mr. Grant, where I have to admit I'm slightly struggling is the argument that at this stage, even with a main modification in line with NPPF 103C, that in some sense the parameters would be fixed and the council would be bound, even if that isn't met, to allow it. And presumably there are parallels with, say, landscape or other factors that it would be incumbent on a developer to demonstrate to the satisfaction of the local authority that that was acceptable. So I just want to get your view on what we've heard there.
Thank you. So yes, we had a number of different things, some of which go to the justification of what Sport England are asking for now, rather than the details of the main mod. Obviously, I'd like to come back on the justification, but I anticipate from what you've said that that might be coming up slightly later. Just on your question of the main mod, we're in line with the council's position on this. Sport England's approach is far too prescriptive, not appropriate for an allocation generally. We don't, as I said, we don't think the wish list has been justified at all. And the inevitable effect of Sport England's approach, dependent in part on England Golf, is to fix specific details and ironically to rule out other better things that might come along. We got Sport England's latest email on, as you said, the 11th of March, statements of case were due on the 19th. It's not reasonable for us to turn around another full feasibility study in 7 days. So bearing in mind where we are, and the question is this allocation sound? In effect, so for you, is there a showstopper? You really, in W. Lamb's view, they really don't need to put the level of detail in this allocation that Sport England's asking for. As you said, so the risks on us with the council's main mod, and it's one we're happy to take. There's also, sir, an element of almost tautology in Sport England's point, which is if you don't do this, then we might not get what we want at planning permission stage. But if it's not the right outcome at planning permission stage, why would it be the right outcome at allocation stage? They're assuming what they're saying is right for the reasons I've hinted at, and you'll have seen we disagree. But it's not clear why that should be assumed to be the right outcome up at this stage rather than at detailed stage where everything can and will be considered in detail rather than based on the broad high-level issues that we've got at the moment.
Can I ask you about, so as you rightly mentioned, a lot has happened in recent days. There's clearly an issue here. Whatever the sort of substance of it, there's clearly an issue here between yourselves and Sport England. Sorry, I can see part of that. So I almost said Natural England. Sport England. I don't want to change your job title inadvertently. There's clearly an issue here that in one way or another needs to be resolved, or you would seek to resolve. We have the timescale for delivery in HM11, which is 2027, 2028, which is means that if we're with the council, if we're with the promoter, that would need to be a deliverable site, as in NPPF glossary B, and that says it should only be considered, a site should only be considered deliverable where there is clear evidence that housing completions will begin on site within 5 years. It was a slight challenge. Well, given, irrespective of the substance of the dispute, there is a dispute that will need one way or another to be resolved, presumably. Can we support that is actually a deliverable site? So that was a sort of secondary thought I had there. Ms. Jones, I can see you're warming up your system. Is that?
Yes, sir, thank you. So 2 points. One is the delivery trajectory has changed slightly, as we covered in the last session, and that's recorded in ED 19A, which is the addendum to our statement of common ground with the council. So it has been pushed back slightly, but it's still deliverable. Fundamentally at the end of the day, as part of the application process, whatever Sport England's view a decision maker, hopefully the council, and not a planning inspector on appeal, but not ruling that out, we'll have to look and take a view, negotiate it. It's a matter of making the case, and then a decision maker takes a view. It's not necessarily a matter that's going to get caught up intractably in negotiations. And for the reasons we've outlined, sir, it sort of bleeds into the justification, which is the justification there, and for the reasons we've set out, we say not. So in terms of your question, is it still deliverable on the trajectory in the plan and disagree with the council? The answer, sir, is yes.
Okay, and I'm just raising that because there is a distinction between deliverable and a developable site. So developable is defined as to be considered developable sites should be in a suitable location for housing development, which I know many people object to, but setting that aside, with a reasonable prospect that they will be available and could viably be developed at the point envisaged. So I'm just setting those out as those are the tests that are in our mind as well. That's what the MPPF says. Okay, let's go to the council. Anything you would want to say on the discussion that we have heard so far?
I think just to add, in terms of the definition on how you can demonstrate evidence of deliverability within the planning practice guidance, we say that there is clear evidence that there's firm progress being made towards the submission of a planning application as demonstrated by the site promoter within their hearing statements, their Regulation 20 representations. There's been a number of technical studies prepared. There's also formal pre-application discussions ongoing, both with ourselves, the Highways Authority, engaged with Natural England through discretionary advice service regards to SANG proposals. And also, although we recognise within our responses that there's currently issues being raised by Sport England and England Golf with regards to the first draft of the feasibility study, that is a requirement for the planning application, and that the fact that a first draft has been shared for comment as part of this stage, again, forms part of that clear evidence and progress to have these matters resolved to support the submission of a planning application in the future, near future.
Okay, now, if we come on to another, and I don't mean to put a rift between, Mr. Warren, you and the people to your right, but I'm afraid I'm going to have to slightly, as in that there is a slight divergence, I think, of perspective, and that comes back to what I've seen from representations in terms of the experience, what has happened locally, and you alluded to Mr. Warren in terms of where an 18-hole golf course has turned into a 9-hole golf course that has then become unviable. And I think that's very much something I wanted to touch on as the experience here and the availability of 18-hole golf courses. From what I've heard, points very much to when that occurs, those facilities in time become unviable. And I think there are a number of examples that have been pointed to, and the nearest 18-hole golf course, I think being a 20-minute drive away, was mentioned as well. So I think there is a slight difference between four individuals here and yourself in that, your perspective is nuanced, if I can say that, Sport England, okay, potentially there's a way subject to a main modification, but really we need to see that now in your view. But the perspective here is that, well, if you're going to reduce the golf course, you may lead to a path that makes the enterprise unviable. So I just wanted to understand if that is a sort of correct understanding. That's also something we will need to factor in and consider the sort of locally lived experience, if I can call it that, of what has happened to other courses. Mr. Burton.
Yeah, thanks, sir. Yes, I have experience in this area from my career at Bourne Leisure, where 9-hole courses were put into areas with high footfall, and they still failed over time and become unviable and repurposed. That's my experience. There's been 9-hole courses in the area that have followed the same fate. 9-hole courses tend to only work as academy courses when pinned to an 18-hole facility and offer that pathway.
Commendably succinct. That summarises in short order what I read from your representation. Let's go to Mr. Pichon and then over back to Mr. Warren. Thank you.
Thank you, sir. Yes, I've been pointing this out for a number of our submissions, that golf courses which are being proposed here have failed through unviability and have stated a number of examples. And the fact that in our evidence we have shown that at least 10 golf courses of that nature have been failed in Hertfordshire, and 3 certainly within this local area of recent times. The pitch and putt proposal which was proposed, and also the 9-hole golf course which has a driving range attached, that has also been struggling and has also failed close by. So yes, we have argued strongly about that point, and I support Chris Burton's statement.
Okay, no, thank you. And I think it was your representation, but it may have been others that pointed to membership change over time, which is growing, work that's been put into place in terms of a sort of progressive route for younger players. So I've got those very much lodged in my mind. I think there is a secondary point, which is the accuracy of the playing pitch strategy, which presumably because it dates from 2019 doesn't account for those, for example. So there's that point that's lodged in my mind. But so bundling those up and putting them to Mr. Warren, your perspective that effectively here the experience is that when you do reduce an 18-hole golf course to 9, what happens is it becomes unviable in time. It doesn't offer that route, that progression that you would need to see.
Yeah, I mean, first of all, I just wish to say that we're not supportive of reducing just from 18 to 9. It would be 9 plus a range of other facilities. So while there might be some difference between us, because I completely understand the perspective of colleagues on my right, if you had a facility mix which had a standard 9-hole golf course together with entry-level facilities such as a venture golf, a full-length driving range, and other facilities, depending on the facility mix and the feasibility which has not been undertaken, England Golf's advice is that could be a feasible option. But I completely understand the perspective of the club that, if you go from 18 down to 9, that can affect the viability, and it has done elsewhere. Well, we're saying 9 plus a range of other facilities could allow the cross-subsidisation, but that would be subject to feasibility and operational detail, which we don't have at this stage. So I can't confirm definitively that it would be feasible to go down to 9 plus a range of other facilities.
Of course, and one thing I would say that I think I maybe said in the other session, and I know your flag's up, and I will come to you, Mr. Grant, is that hearings can be unsatisfying events in that it's our role to hear the evidence, to think, to reflect on that. We will need to go out on site and we'll need permission, I presume, to walk around certain parts of this site. So we will need very carefully to reflect on what we've heard, but it's just to lodge that in your minds. Mr. Nicol.
Thank you, sir. In terms of the kind of 18-hole to 9-hole, just like to point out, so we conducted the detailed study which was produced for the previous hearing, didn't involve any outreach to the golf club members itself or the committee. We represent the golf members. We conducted a short survey upon receipt of that. And the feedback that we received is really that, that the provisions A or B are not provisions which would serve the membership. So our membership has increased. It's 250% of what it was in 2019. We have 400 members, and we had a very minimal acknowledgement of either option A or B as being something which would provide golf for the membership. And it's not our job to find mitigation, But if we look in the local area for the clubs that we know, because we know members there, we play those courses, we see very little availability of 18-hole golf courses at the same pricing point. So, my reading of Betterment or the Part C is that the proposals are not designed to support the existing golfers. They are for some other to be determined group of people.
Okay, thank you. That's yeah, very clear. If I can possibly turn to, it's possibly Mr. Swan, it's possibly Mr. Grant. So there are a couple of key points in there, having opened up a rift between Sport England and others. The issue of, based on what has happened, and we heard from Mr. Pichon, there are a number of instances that he's put in his hearing statement of sites that have changed that level of provision from 18 to 9 holes and have become unviable in time. There's that point that I think it would be useful to get your view on. Also, the view on the sort of playing pitch strategy, the 29 playing pitch strategy, effectively a sort of input to considerations that doesn't take account of things that have happened since. And we've heard in terms of the viability, the membership numbers, and efforts that have been put into providing a kind of pathway from junior golf through in the course. So can I just get your views on, I don't know if it's, sorry, I'm sort of looking nebulously towards the water jug there, but yeah.
Yes, no problem at all. I will bring in Mr. Swan on viability generally. I just want to make, and the viability of 9-hole courses. I just want to make some broad overarching points, if I may. First, there seems to be an implicit assumption that the 18-hole is currently viable. I know that is the view of those on the golf club committee, but it's based, sir, on things that we don't think are accurate. Just taking membership numbers as an example, we asked the operator last night to confirm membership in light of the 400 number that's been floating about, and we've been told in no uncertain terms membership's down at 320, not 402. Now, so obviously we're in a hearing and it's difficult to resolve that without fuller evidence, but what that does is, if it's right, then bearing in mind the business calculations that have been appended to one of the golf club committee statements, if you take 402 down to 320 and multiply it by the 926 odd fees, that gets you down to a 6k pre-tax profit, not an 80k pre-tax profit, or pre-interest profit, sorry. And that's not taking into account, different memberships paying different amounts, etc. So there seems to be an assumption 18-hole viable, 9-hole not, so therefore we shouldn't do it. And so we don't accept the basis on which that's being put. I appreciate it's difficult for you to resolve that where we are.
Yeah, okay, and I know there are rumbling disagreements about viability, and we're not in the, and I think you fairly caveated that, we're not in the territory of a Section 78 inquiry where we would pore over the figures. There's clearly a view that, and I think it may have even been in Sporting, I was trying to look for it, that potentially an 18-hole course is viable. It may have been in Sport England. Anyway, that's by the by. Clearly, what is at issue is the viability of what's proposed and MPPF paragraph 103C, whether provision would, how alternative provision, reduction of golf course size would affect that. So I know certainly there's an issue, and thank you for coming out to your comments. I don't want to get drawn into particular viability points. It was now Mr. Swan.
It will be Mr. Swan. Yes, the reason I was making the viability points, as I say, the caveat is we can't resolve it. It was, there was an implicit, what we've got now is fine, and what we're proposing won't be. And that, sir, I'm obviously does come into the 103 balance to an extent, which is why I'm pushing back on the assumption. I also, sir, mentioned it because you explicitly mentioned membership and viability as examples of factors that might have rendered the 2019 playing pitch strategy out of date. And again, so that's points that largely let the council pick up, but of course the playing pitch strategy has been reviewed in later iterations, most recently I think 2023, HEA 08, and that is the one that flags the absence of starter facilities for golf. I can give you the precise paragraph reference in a moment. In fact, I'll look for it while Mr. Swan's speaking. So those were the other point that I wanted to pick up, sir, is you mentioned the nearest facility might be 20 minutes away. I think Little Hay is 13 minutes drive away from Shendish, and Centurion is 10 minutes drive from Shendish. So I just wanted to flag those two. And I will let Mr. Swan then come in on viability, and then I might pick up the point that's being made, which is it will help newer people in the game of golf as a whole rather than the current extant members of the club.
Yes, I think those are all point, and I know there was some rumbles about the distance of those sites, so I'll clarify that. I don't want to get into sort of tit for tat or any. There was one point which I can't quite understand. So obviously we have individuals on this side that are very well connected with the golf club. You've got past, present captains. There was mention that you called up the golf club and got a view on membership. So I'm just trying to work out because we have the captain, we have the incoming captain. So I can't quite work out who's telling us what. Yeah, Mr. Grant, then Mr.
So we spoke to the operator of the golf club. Obviously, you'll know that there's a note appended to our proof from Mr. Shung, who's the owner-operator. We emailed the operator yesterday. That's the people that run it, and this was the membership number we were given. Also not entirely clear why it doesn't match with what the committee and the captains seem to have, but so we explicitly put the number 2 and the 402 that's being raised, and we're told in no uncertain terms that's not right.
Yeah, I'll come to you, Mr. Swan, but I just want to clarify this point.
Yeah, so keen, thank you, sir. Keen not to get in a tit for tat, like you say. I just wanted to provide some context of what sits behind our numbers. So the operators own the golf course. It's the committee that run the club. So as a committee, we took over. So in 2013, the committee took over the responsibility of running the club from the operator, and everything comes through the committee. We administer the software, not just internally in terms of club systems, which is the system we use that supports the membership, but also England Golf's own figures through the World Handicap System. So there's national body software that also supports our numbers. We have, a unique list of this information, but fundamentally we're the actual operators and the administrators of the golf course, not the owners. So everything comes through us. Our statistics are backed up by the software and the systems that we use nationally to support our members.
And while you're on the sort of digital line, as it were, there was mention of some golf courses, Centurion Club, which I've driven past, and something Hay. Sorry.
Yeah, so there's a couple more points, if I may. So we actually had our AGM last week with the owners, and the owners are present within all our minuted meetings as a committee, and we specifically request them to validate the minutes of those, and those minutes include some of the reports that we include in our own submissions around the membership numbers, and they also confirm with us through those meetings that the numbers that we have are the numbers that are factually correct. In regards to the courses locally, the key importance is the attainability of those courses. So when we mention Centurion is a £7,000 a year membership. So it's an exclusive club. It's not pay and play. You can only play there as a member, and it's for local, elite people. There's other courses even further than that, Berkhamsted and Ashridge, which are also referenced in the report. One of the Ashridge is actually mentioned twice as an artisan and as a golf course, as if it's 2 courses. It's a single course with an artisan membership. But both Ashridge and Burko are currently full to capacity, and they both have waiting lists, and that's also acknowledged in the Boyer plan. So while there are courses locally, there are blockers in terms of any membership migrating to those. And beyond that, another point, if I may, the entry-level piece into golf is quite important too, because Little Hay, and I don't believe this is referenced anywhere, also has a pitch and putt and foot golf course. So they already provide some of the leisure facilities within the area that we're portraying as being needed here. And in their own submission is only 7 minutes away or however many, 13 maybe, sorry. So there's already those provisions sitting within a municipal course. And those things can be expanded. So that kind of concludes some of my point.
Thank you. That's useful. So I presume it's Mr. Swan or Mr. Grant. Just that was a helpful, helpful clarification in terms of the evidence we have to go on. And I do want to move on to SANG and sort of overall capacity. But in terms of the evidence that we have to go on, presumably the golf course assessment was informed by discussion with the operator, but potentially not with the committee.
Good morning, sir. Yes, that's correct. The relationship between the ownership of the golf course and the committee, I'm not fully aware of how that works, and I don't know the basis of the discrepancy in numbers from the, as I say, the owner and the golf club. However, I think on a wider point, it's fair to say that golf has changed significantly since 2009. The golf market has changed significantly since 2009. There is demand for golf. There is good demand for golf. It increased significantly during and post-COVID, undeniably the case. And you can see that within the national market and the local market that some golf courses, many golf courses are busy. As mentioned before, Ashridge and Berkhamsted as local private members golf clubs are essentially full and operating with waiting lists. That is certainly true, but in a different segment of the market and within the differentiation between how golf courses and golf clubs sit within the market, not all golf courses are full to capacity, and Shendish Manor is clearly not operating at full capacity or anywhere near full capacity. And I believe that's also the case with Little Hay Golf Complex. Both fall within, I guess, Sport England's categorisation as a standard 18-hole golf course, albeit operating at a lower price point than the private members clubs in the area. So there are question marks on viability as to if there is such high demand for golf and for 18-hole play on 18-hole golf courses, why are those golfers not coming to Shendish Manor? Is Shendish Manor satisfying that demand, the specificity of that demand?
Thank you. I don't know if it's Mr. Grant wants to come. I do want to sort of, excuse me, it's 11. I do want to move. I do want to sort of move because I've got a very good handle on the detail. Do want to move on to the issue of SANG and overall capacity, as I think that's another kind of angle. But Mr. Grant.
So just a couple of points. You specifically asked about the viability of moving to 9 or other projects, and I don't think Mr. Swan's come on to his answer on that yet, so I didn't want to leave that hanging for you if I.
Yeah.
I think that you pointed out earlier that there's almost a gap between a perceived gap between Sport England's position and the position of the project in terms of a proposed mix of facilities. I think actually that gap is very small in terms of our proposal, option B in our draft feasibility, first stage feasibility, that it would include a 9-hole golf course, a driving range, adventure golf and associated practice facilities. There's, for sure, continued discussion about what exactly the form of those particular items, particular elements of the mix of golf facilities, but we're in broad agreement that the same ones should include, and there is evidence from elsewhere, again, relatively short-term evidence, and I don't know how it compares with the aforementioned closure of 9-hole golf facilities and when those happened in the locality, but our experience, with this higher level of golf demand and changing golf demand is that the variety of facilities to allow people to play on standard 18-hole golf courses is actually matched and has changed extensively, so that there is a much broader array of golfers wanting different things from their golf facility, and that a wider array of facilities will not only allow existing members to play on, albeit not an 18-hole golf course, but a similar standard facility, an improved facility on what is already there, but it then offers a market to a different market, different facilities for new golfers, and very much talks to the same point as the Golf Club Committee makes about a pathway, and exactly the pathway that England Golf put forward as a model for development.
Okay. Thank you. Mr. Warren, I'll come to the council, then we'll talk about sang incapacity. Okay, thank you.
Yeah, thank you. I just want to come back just to, as a point of clarity. I think there is perhaps a wider gap between myself and Mr. Swan on the option B as presented in the golf investment strategy. The option B, the 9-hole course, was a par 3 pitch and putt golf course. That's not the same as a standard length conventional 9-hole golf course. Pitch and putt is more aimed at people with shorter time, but usually more beginner users. And I'm not disputing there's not demand for that, but it is a very different type of facility to the standard length, which is more, conventional golfers. So it would be a different facility. Those using a current standard length 9-hole course wouldn't, let's say, less likely to go and use a pitch and putt facility. So, and the view is that, England Golf's view is that there is still a strong demand for standard length ones, which are much more difficult to replace because of their space requirements. So I do think there is that gap. I just wanted to sort of make a note of that, so you're aware that there is that distinguish between, pitch and putt and standard length golf courses.
Yeah, well, I understand that. I'm perhaps speaking a little bit beyond my role, but whatever happens, it seems like there needs to be some sort of communication between all the parties, because it's quite surprising that there are slight differences of perspective. Anyway, okay, council, insofar as we're concerned with the local plan, anything you want to observe, you want to comment on what we've just heard, then I'll come on to sang capacity, potentially we'll come back to delivery expectations. Thank you.
Thank you, sir. I think firstly, just to touch on the evidence point that Mr. Grant made, we've had a number of updates to the original, well, I have 2 updates to the original playing pitch strategy. So we've got 2019 study, which is HEA 05.1, and then the subsequent updates in 2021, which is HEA 07.1, and the playing pitch strategy update 2308.1, identify need for entry-level golf facilities. Second point is that most recent assessment, so HEA 08.1 is paragraph 8.3, identify that the lack of facilities catering for an entry-level golf generally in the borough, and that there's an undersupply of off-course and starter-focused facilities as a significant issue for the sport within the borough. So that's the evidence supporting the local plan. The original playing pitch strategy, they should be read together, the 2019 one and then the updates. The original study, as I mentioned, said that there would be a need for a full assessment to be undertaken whenever golf courses are identified for development. That's something that has been undertaken. So the most recent detailed needs assessment undertaken by Boyer for W. Lamb concluded that there's a range of 18-hole golf courses within the borough. I think that's their hearing statement, Appendix 4, paragraph 7.10. And then the largest demand for golf arising is from younger and casual players, and that there's currently a lack of facilities catering to that market with the potential to meet that demand. and that's their Appendix 4, paragraph 6.12. And just to bring it back to the start point that we made, the addendum to the Statement of Common Ground with Sport England confirms that the detail of the mitigation should be agreed at the planning application stage, subject to the further detailed design and feasibility work, but there's a principle that a mitigation solution could be identified on this site, and that we wouldn't wish to restrict the ability of a planning application to respond to further updated evidence or changes in circumstances which take place following the adoption of the plan.
Okay, thank you. And I don't think I need to look over here because I've got your perspective in terms of the availability of other facilities, what has happened to elsewhere. So I've got those too. Okay, Mr. Grant, did you? No, that's all right. So just from sort of moving, if you like, and obviously we'll have to take things away, think about them, go on a site visit, etc. But just from two other points I wanted to touch on. We have the capacity of around 500 dwellings, which I think I'm right in saying inevitably entails there is no way you could have both an 18-hole golf course and that number of dwellings. So are there any implications, I think, of the lack of an alternative that satisfies Sport England in terms of capacity? That's my first question. And what are any implications for suitable alternative natural green space provision? Given there have been some concerns, Councillor Anderson raised them previously, in terms of, well, how is that counted? Where do we go in terms of the evidence on SANG? So it's those 2 points. I don't know if hopefully I've articulated those reasonably. Maybe I will come to the council first, just on those 2 points, if I may.
Thank you, sir. So from the council's perspective, in light of where we stand with regards to the modifications that we believe are acceptable, we don't think there is an issue with regards to this. The nature of SANG and the land needed for SANG is in some way flexible. I think one of the kind of key requirements regarding SANG delivery is that it should be seeking to meet the minimum circular walk of 2.3 kilometres, and that's spelled out within our habitats regulations assessment and our mitigation strategy. But that can be achieved on land that can be as low as 12 or 13 hectares. It can, and anything above that. We would generally say a good rule of thumb, it can be 20 hectares or more is a really kind of good rule of thumb. But that's not to say that through careful landscaping and planting in other areas that SANG, area is a set figure. I think as long as what is delivered as a SANG is acceptable both to Natural England and to ourselves as the competent authority, then we'll be comfortable that the requirements of the mitigation strategy is there. So the real kind of rule, hard fast rule is Natural England's one is 2.3 kilometre circular route. Again, how that is delivered on the land and this allocation is something that I believe we've got some comfortability and confidence in what we have seen to date, that the mitigation solution is there. But it's not to say in our view that the provision of replacement golf sports facilities alongside this additional alternative recreational provision, importantly as well in the context of 103. C of the framework, and the benefits that will bring. We don't see any issue with regards to deliverability and a solution for both.
No, I think that's clear. I mean, obviously, in our mind, if a SANG solution has to be found, even if it's on site, that isn't there at present, there are potential implications for getting that up and running before you occupy dwellings. So again, I'm just saying that, I'm giving a fairly clear indication that we find the 2027 to 28 delivery to be on the optimistic side. But just if I can press you on one point, which is what Councillor Anderson may say, can SANG and any replacement golf provision coexist? Can they overlap? I mean, you mentioned alongside.
I think the short answer for that is yes, and there's probably 2 points on this. And this is, again, having regard to the discussions, long, lengthy discussions we had with Natural England. We undertook a wide range of visits, particularly in the early days, to identify how we identify mitigation solutions in the short term regarding saying, particularly with regards to the local plan. But when we were in the more, as I mentioned yesterday, we weren't able to grant any net new dwellings for a period of time in 2022. And we had 6 months from the time that that evidence was published to developing a mitigation strategy. We went out with Natural England and surveyed quite a lot of sites, some of which are now live and active SANGs that we are managing and maintaining at Hemel Hempstead. And in certain circumstances, we did look at other land, including golf courses in the area too. So we just mindful that we do have other golf courses and stuff. And one of the key important points of feedback from Natural England is that it is very, very easy to translate an existing golf course or part of a golf course even into a SANG. That is kind of the first point I think that was made. So that's with regards to, you know, what needs to be done. These places are well landscaped, they've got a lot of trees, there's a lot of maturity and things like that, naturalness that can be easily kind of converted into a natural green space, alternative natural green space of a high quality for, you know, open recreation use. The second point then is whether the two can coexist. I have no issue with that in terms of the context. There's nothing, it's about the need to deliver, you know, a tranquil space. And with that, we're being mindful of, you know, neighboring uses. But we know in other instances, when we look at some of our other, you know, other considerations of SANG allocations, etc., you know, we are having regard to proximity to, say, the A41 in terms of noise, in terms of those impacts too. But when it comes to golf clubs and the functional use, that's not incompatible with the mitigation strategy and our principles for SANG, which is that it is, you know, that is more of a natural feel that would sit alongside the delivery of a SANG.
Can predict, knowing me over these past few weeks, what my next question is going to be. What have Natural England said about a SANG solution here, potentially, in that respect? So I don't know if that's a question for the council. Mr. Grant?
So Natural England are fine with it. You've got appended to our response to this hearing, thing we put in response to ED49 Appendix 5, you've got Natural England's discretionary advice service response. Yes, sir.
Typically, I've only got that digitally. Can you just talk us through then very precisely what Natural England have said in terms of the potential overlap of functions while I load it? Thank you.
Sorry, sir, I don't. So it starts at PDF page 62 for your digital note. I will double check. I don't think Natural England addressed specific overlap functions because Natural England has been advising on the SANG solution that we've provided, and it's not our intention to have something being both golf course and SANG. And we're confident, sir, we can deliver the minimum amount of SANG required without any sort of overlap in line with our option A or option B solutions. So we don't get into that question of overlap and hope, I appreciate, I think some of the concern may be arising because option A in the note initially has some land on where currently the SANG would be. And so if we're going down that road, we'll have to find some other point for additional compensatory SANG, but we're confident we can do it looking at the minimum requirements for SANG for this development. At the moment, there's over provision. So it's certainly not our intention to have land doubling as SANG and golf course, okay, if that helps.
I'm going to ask a howler of a question here. While you're on the line, at the moment we have key development and land use requirements around 500 dwellings. That seems to be consistent with other allocations, but how would you feel about up to 500 dwellings? And the reason I'm asking this is there's obviously a concern that at present, as drafted, so this isn't just me thinking, well, what could we do? At present, there's a concern, so I'm just going to explain, about the ability of the site to deliver everything that's been suggested. And if I'm just articulating the perspective of, the golf club, clearly, in principle, things that improve viability, that improve the offer, that's a good thing in principle. What isn't potentially a good thing in principle is the level or the amount of not only homes, sang, whether that can all sit comfortably in the site. So my thought would be, well, actually, if there are these debates to be had about golf course replacement, to the satisfaction of Natural England, if there are the debates to be had about overlap of sang functions, are we not talking about an allocation that in a certain instance talks about up to 500?
So we think not, based on the basis that the master planning work hasn't yet been done. As I say, if you're looking at sang, for example, as the limiting factor, we're currently over providing sang. And that's a point that Natural England acknowledges in the consultation response that I've taken you to. So sang could be reduced to facilitate 500 dwellings, or we might over-provide it, which inevitably then might help other developments come forward, again, which is a point Natural England makes, which is our sang can provide for potentially some other developments as well. So up to 500, so we say would be unduly constraining. Leaving it at the term used allows that detailed design work to be done when all the trade-offs can be considered in detail where they should be, rather than this broad high-level approach at this stage, which is a necessary function of deciding an allocation rather than actually designing a specific scheme. So you might appreciate the concern about wanting it to be up to 500 dwellings for certainty, but in imposing that certainty, you might actually rule out some betterment. And of course, if we get to that stage and an application were to come forward for 700 dwellings and under the less, not fully meeting that saying, then it would be a basis to refuse it because it's not in line with the allocation. So leaving the precise balance over to another day, which is what this does, seems in our respectful submission sensible, good planning, basically.
So in essence, no justification for a kind of limit, if you like, up to 500 from your perspective. Okay, Ms. Mitchell.
Thank you, sir. Just to add to that, within our response, so it's matter 5, issue 1, question 2, we noted that our approach to using the around figure is to ensure that the master planning stage could be flexible to respond to specific characteristics and the circumstances of each site. We said the master planning stage could determine that the sites could feasibly deliver more or less than that figure. And that's an approach that we've taken across our allocations within the plan. I remember at the very start of stage 3, we discussed the use of around versus approximately. But if I recall, we concluded that we wouldn't use up to or limiting figures.
I mean, I think that's a fair point. It was just in this particular instance whether there's a justification for that. Another way, I mean, you mentioned these sort of master plan requirements. Another thought, given there is if I can drop the sort of professional veneer for a second, there's a lot going on with this site. Maybe if the urban design principle, the master plan, sets out more clearly what is required in terms of a comprehensive phasing plan, which addresses sang, golf course provision, various other things. There's more clarity there in terms of what the master planning process would do. I appreciate that, but that wouldn't overcome your first concerns. But that may give more certainty in terms of how things are going to proceed and where in that process, for example, different elements of the site are going to come forward. Just a thought.
Are you looking for responses on that, sir, or just mulling?
Or just talking? Yes.
I mean, if it helps, and obviously it's for the count. up to the council. We wouldn't in principle be opposed to that, but would want to consider the wording just in case you end up, just to accommodate a situation where you have one master plan, but for example, separate planning applications pursuant to that plan. So matters of detailed technical points rather than in principle. So if you consider that's necessary, then it's not a point that we'd particularly take, but that's us thinking on the hoof.
Councillor Anderson.
Thank you. I've got a whole shopping list. I'll try to be brief because a number of issues have been raised there. I don't know if it's a benefit or a disbenefit, but having been the portfolio holder at the time when the council was required to set up the mitigation strategy under the natural habitats legislation, I've gained, rightly or wrongly, quite a lot of experience on the subject. I agree that the provision of SANG can be flexible, but the requirements of it are laid down in law. And that being the case, it could be argued that the requirements themselves are specifically unflexible. In terms of whether you can double count SANG and golf facilities, the rules or overlap or even abut each other. The rules are explicit. The SANG has to be open parkland that members of the public can roam over without interference. Whether that involves golf balls or whatever, the rules on that are pretty clear. I did write to the operator owner before this whole process started to alert him to the issues over the SANG, and I received a response that that Natural England had waived the requirement for SANG and it wouldn't be needed in this case. I've still got that letter. Unfortunately, that's not the case because not even Natural England can waive the requirements of SANG. It is actually laid down in law, and there's no measure under law which those requirements can be changed. So they're not actually in a position to be able to waive the requirements for SANG. Similarly, so you cannot say, oh, well, we can sort the SANG out at some later date. There is many precedents and appeal decisions that appeal that the SANG provisions have to be provided up front. You cannot leave it for discussion down a later date. The precedent, I'm aware of the Rectory Farm appeal in April 2024, which is in the same ward of King Langley, ironically, where a grampian condition was put in place to allow the provision of SANG. But in that particular case, the SANG had been clearly identified, planned, and was part of the picture, as it were. So it was in place. This is a different case. The SANG is actually on site. It's not elsewhere, and it has to be provided up front. The numbers in terms of the amount of development, it is key about whether you're talking about 500 or 600 dwellings, because the requirement for SANG is 0.0192 hectares per dwelling. And the requirements of that are quite clear. So we've got another example here of vagueness and doubt creeping into what is actually being proposed, as if there isn't enough already. And finally, on my shopping list, for reasons that objectors haven't been able to understand, this HM11 was included in the workshops to do with Hemel Gardens Community Project. And they've already developed design codes for this development. So for those to argue that there's been no detailed planning at all isn't, I think, from my point of view, factually correct. And I do believe that that kind of design work has already taken place. And that's possibly why the figure was raised from 500 to 600 dwellings. I don't know, I can only speculate on that. But it's a further illustration. Yes, there is, I would accept that the SANG is adequate. It's not, it doesn't exceed requirements. It's adequate if the plan proceeds with the option B for the golf facilities. But it is unclear, as I've made plain in my written submissions, if option A is pursued, there is no way that can be achieved with or without Sports England's shopping list, without actually reducing the amount of SANG below the legal minimum.
So you saw me looking up into my mind at that point. And this is, I suppose, a question to Mr. Grant. So that the point being put about the legal basis for saying that habitats regulations assessment, you've got to do an appropriate assessment. Section, not article. Anyway, thank you. I knew I had a 3 in it somewhere. Yeah, and the appropriate nature conservation body being Natural England under section 62.3, you have to engage with them. So I suppose my question to you is, what do you think of Councillor Anderson's points there, given that you would you not, in any planning application, have to satisfy the requirements of the Habitats Regulations Assessment in terms of appropriate assessment? So is it another case of, well, it would be your risk? Okay, Scott.
Yes, I mean, starting with the legal requirements, as you'll know, so the requirements of Reg 63 are that there has to be no adverse effect on site integrity, and that has to be set out before any permission, consent, or authorization is granted. So that's on us at planning permission stage. Exactly how that is met, so is obviously a matter of judgment. SANG is the way that it's being used, and so again, so we'd have to satisfy the council that we can pass that, and of course Natural England would need to be consulted, as they already have been. And as I say, so you've got their response, which confirms we are over providing. I know Councillor Anderson doesn't think so, but Natural England, who are the statutory body, do. In terms of the points that it needs to be in place prior to occupation, I think so it's important to separate out that this is an allocation in a local plan. It doesn't grant planning permission. If you allocate this site tomorrow, we can't, of course, go on site and start building. We still need to go and get that planning permission. And if that requires a pre-occupation condition to make sure the SANG is in place before occupation, because of course the SANG is about where people go to walk their dogs, for example, that condition can be imposed, and we'll obviously comply with it. We have, sir, a master plan that adequately sets out where the SANGs are, and some golf course provision with the any required separation distances. So that's why we're very comfortable we can do this. Yes, there's a lot going on, but that, sir, is in line with the direction from the minister to get homes built, and that requires sites where there's a lot going on. The suggestion that there's vagueness, there is no vagueness. We've got SANG, it's outlined. There are minimum requirements, which, as I've said, so we are very confident we can meet. Not clear where a reference to 600 units comes from. If it was my ridiculous example 2 minutes ago, that was just me showing that allocation doesn't always equal permission. I'm not aware of us coming forward with a 600 unit scheme at all. And so I think that, there's a point saying that there are design codes and whatnot already in place. Also, there's 2 things. As I said, we need to separate the planning application from this allocation. We're making progress on the planning application, and we've been very open and upfront about that. Obviously, therefore, some work has been done. It will need to be reviewed in light of what you decide for this allocation, but it's not for us through our application and design codes at this stage to be responding to points that are detailed points that are being raised in these proceedings. They're separate. So we've done sufficient work to ensure that we're comfortable, sir, and can say to you that we're comfortable without worrying about it. But in terms of the points that have been raised fundamentally on the SANG, it can come to a head at application stage, because that's what Reg 63 is for. We're comfortable that we can do it, or we wouldn't be spending time and money pursuing this allocation, given that the Habitats regulations, sir, as you'll know, are effectively a veto. Doesn't matter how important housing is, if we can't show no adverse effect, we don't get our permission.
Okay, and I was just, I was listening very intently, but I was also looking at this very specific provisions of criterion 5. Deliver SANG on site to offset potential adverse effects, unless an alternative solution is identified and agreed with Natural England. Okay, so I think very clear on the arguments. As I say, we'll need to take some things away, reflect on, and go on site. As a minimum, perhaps, if I can say it this way, there needs to be some work, and I think the council will see this coming, on criterion 4 in terms of the golf investment strategy, in terms of consistency with NPPF paragraph 103C. I think you've seen that coming. Maybe advisable to work with Sport England, but I know that there's a difference of opinion there. But as a minimum, that needs to be consistent with or articulate NPPF paragraph 103C. I would also suggest that in terms of effectiveness, in terms of giving a clear basis for decision taking, and I hope of some reassurance to people, that the master plan process showing a comprehensive phasing program, arguably it's already in there in terms of what goes on, but that could additionally specify any alterations to golf course provision of sang, etc. Maybe not etc. That was me ad-libbing. But just to make clear the sort of the different process to when elements of the site will come forward. And I think that would be useful and potentially of some reassurance. But as I say, there's a lot for us to take away and digest. Are there any other, with all that said, are there any other points on question 7, HM11, that anyone wants to raise that they haven't been able to? Councillor Anderson. Anyone else? Mr. Grant?
This is completely overall to question 7, not just...
This is completely overall,
right,
yeah.
Okay, there's just, I would say, 3 or 4 points briefly I'd like to make, sir. Yeah. First off, we have heard on 2 issues this morning, the expression being used that if any problems occur at the planning application stage, it becomes the developer's risk. I would dispute that because you're particularly with the issue over saying, never mind deliverability, you're actually getting to the application stage before you're actually considering whether something's viable or not, or legal. And I think it's a key argument to say that's too late to do that. The deliverability of this scheme, both in terms of golf and sang, have to be determined now. They are not issues that could be left to later on. So that's point number 1. Point number 2, it won't surprise you to understand, it's almost about the same, but it is the view of objectors in terms of that crucial NPPF 103 paragraph C, that as was kind of roughly paraphrased earlier, it is our view that what's in place now is good, is fine, is working. And that what is proposed in future is unviable, unworkable, and in one case illegal. That's point number 2. And point number 3, I know this isn't tit for tat, but I'll make 2 points, quick points off the back of the last contribution. The last summer's statement of common ground between the council and the promoter clearly specified 600 dwellings, not 500. I actually remember commenting on that. And secondly, it is, in terms of the Rectory Farm appeal hearing that I mentioned earlier, it was counsel for the council that repeatedly argued that Natural England did not have the right to waive sang requirements. And one can look up the transcript from that discussion to actually understand the point. So it's not just me saying it, it is the profession saying it. And those are the points I wanted to raise. Thank you, sir.
Thank you very much. I made a very careful note of those, and absolutely the kind of the legal and policy basis for examining a local plan. Absolutely, we'll give that careful consideration. Mr. Nicol.
Yeah, just 1 point. I know that we danced, thank you, sir. We kind of danced around the inconsistency between the detailed feasibility study numbers. Should there be some action just to square the circle between the material inconsistencies between the playing numbers and the demand that we see from the Golf Club Committee and the numbers in the Boyer report?
Should there be some, in terms of what we can direct, I'm not going to ask that, because from what I hear, there is a view that the golf course is viable. There's a view that, well, potentially it's viable. I don't know if that's a phrase, potentially it's viable, or could be improved in terms of viability. So in terms of the detail, that's why I'm, from a local plan level, we don't need, because I've got very clearly there's two sides, so I don't need to, that's not critical, if you see what I mean, to our thought process. So thank you for raising it. I'm very well aware of what has or hasn't been done in terms of communication. So that is the, another point, another angle to it. So thank you. Was there another point, Mr. Nichol?
No, that's it. Thank you.
Thank you. Mr. Warren.
Yeah, I just want to make one further point because I wasn't able to make it earlier. We always engage, with promoters and local authorities to see if we find solutions when we get paragraph 103C debates. And the focus has been on trying to find alternative mitigation that could offset the loss of 18-hole course. But what my view would be that none of the evidence being presented as the council strategy, the work undertaken by the promoters, it's not been demonstrated that an 18-hole course is surplus to requirement or that there's not enough demand for it. So the clear view that, if this development didn't progress, there still will be demand for an 18-hole course. It's not been proved otherwise. We would be comfortable retaining an 18-hole course. But we've engaged to see if there are other solutions. We put forward the minimum mitigation package. And because that's the minimum, that's why we're so insistent on it being demonstrated that there is capacity, given the importance we've heard of meeting the requirements of the SANG, and obviously maintain the residential capacity of the site. We don't think that's a matter that can be left to a planning application. We need a policy steer right from the outset. And that was also.
Okay. Thank you. Mr. Grant, then Ms. Mitchell.
Sir, thank you. You've directed the council to improve some wording around the golf course provision, referring specifically to 103C. Could have just possibly asked that it be 103 rather than 103C, because also there may be arguments about B as well, depending precisely on what comes forward. I don't think we're making an A argument yet, but given that the MPPF policy is 103, perhaps we could just refer to that.
Keep going on some other points. Let me just have a think.
Thank you, sir. Appreciate that. In terms of the point about 600 units in a statement of common ground, so that was admitted to be an error. If that's where that's come from, I think we've already dealt with that. That was just a typo. In terms of waiving requirements for SANG, we're not waiving it. We've complied with it. I'll leave over arguments about surplus to requirement. We're not particularly heavily relying on 103A, as you'll have picked up, but there are questions about utilisation and stuff, but those are matters of detail, sir. So that picks up those points. Fundamentally, sir, the question is whether this can comply with paragraph 103 of the MPPF. The answer, for the reasons that we've set out. Is there a point you? Sorry, sir. You.
Yeah. No. I'm just thinking if in the plan as submitted. So obviously to recommend a main modification. Sorry, I'm going over territory. To recommend a main modification, we need to be satisfied there's a problem that would be rectified by soundness. If I look at criterion 4, applicants will be expected to prepare a golf investment strategy which demonstrates how new and enhanced golf facilities will be provided on the site. So that seems very much is that a 103C, the developments for alternative sports and recreation provision, the benefits of which will clearly outweigh the loss of the current or former use? Or are we talking about a paragraph 103B, that there's replacement in terms of quantity and quality in a suitable location, which may suggest that that is not on site? I think the key, as I see it, is that the plan seeks to prepare a golf investment strategy which demonstrates new or enhanced facilities on site. So I just have a little bit of hesitance about introducing something that potentially allows for provision elsewhere. That would be my only concern. So I think it's absolutely fine to reflect, sorry, if I square the circle, absolutely fine to reflect, and indeed encouraged to reflect paragraph 103. But in terms of, as we understand it, very much the intention is on the site. So as long as that is retained, I think reflecting paragraph 103 is fine. Okay. Anything the council would like to say? Ms. Mitchell.
So if I could invite you to look at the original statement of common ground between the council and Sport England, that's DBC ED 48. It's all right. Let me know when you've got that.
All right, I will.
Have you got that open? Not yet.
The ED48A, but that's the wrong one. Yeah, I'm there. Whew.
Brilliant. So pages 2 and 3, we originally agreed with Sport England some suggested main modifications to criterion 4 and 5 of the social and community requirements of policy HM11.
Yeah.
We also agreed this within the addendum to the statement of common ground, which also clarified the capacity within that trajectory. That's ED 19A. So that these suggested modifications prior to the deadline for written statements were agreed between all three parties. So that slightly changes the wording of 4. Firstly, clarifies that the golf facilities can be provided and delivered on the remaining Shendish Manor golf course site. So it just, again, there's that point about overlap with the uses within the red line boundary versus the remaining golf course left in the area. It also provides more clarity on what the scope of that strategy would need to consider at the application stage. And then we've also suggested an additional criterion, which is criterion 5, which seeks to clarify that point on phasing, noting what the not the applicant, the site promoter said about what will be delivered and when. One thing I'll note as well, that within the addendum to the statement of common ground with Sport England, that is 48A, that Sport England advised that if what they call the minimum mitigation, which they've identified at the moment, couldn't be included within the policy, our position is that it shouldn't be included in the policy as a minimum requirement. But they say that if that couldn't be met, however, the inspectors considered the allocation to be sound, then they continue to request those proposed modifications originally agreed within ED 48. So I appreciate they don't explicitly refer to the paragraph within the framework. I'll take that on board, but I just invite you to consider it in light of those suggested modifications.
I think there's clearly some work to be done making sure that that all aligns. But thank you for raising that. I think that's helpful. Okay. Well, let's have a break. Come back at 12. And then we'll deal with any administrative points in terms of main modifications, site visits, any actions. But thank you all very much for your contributions. I really mean it. And in terms of HM11, it's given us very clear understanding. So thank you all very much for your time and work. Okay, let's adjourn back at 12. Thanks. Okay, thank you. Let's resume. So, yep, almost there. And maybe I took perhaps too long of a break, but I was just getting down the various administrative things which I could be useful if there are any things that we can talk about. Do say. But in terms, so on my list, site visits. Is we likely in the coming few weeks, early to mid-May, can't be precise on those because it depends on availability, other work. We've talked about today sort of permission to go onto the golf course. We've also talked about that we'll need permission to go to the school sites, BK03, BK04. If there are other sites that we need to get permission to go on, I don't know if there are any other sites that sort of immediately pop to mind. We'll look through them, and obviously if they're public rights of way, fine. If we need to go onto private land, we may have to get in touch with someone, and that will probably be via the council. Just to, yeah, I don't know if there are any other sites that immediately pop to mind.
I guess it's a question really. I'm thinking of HM02. It's an urban site. You can see it from the roads, but to actually get onto the site, you'd need someone from the council to open the gate.
Is it BFI? No.
Civic Centre.
Oh, okay. Sorry, HMO2, not BK. Okay, no, that one's okay because we can walk past it. So thank you. But I mean, if you want us to go on site, we can. But I mean, no, that one. You're right. HMO2, I've been past. Okay, thanks. And well, if we do encounter any issues, we'll or if we foresee any, we'll be in touch. But okay. In terms of other pieces of work or actions, yeah, I think we mentioned maybe at the start of last week, do start forming up a comprehensive list of or schedule of main modifications. Do kind of, if I'm sure you've already started on that process, and I know there are lots of main modifications that we've talked about, so thank you for taking into account all of those. There are lots that you have put forward preemptively in your hearing statement. So yes, compiling a list of those in terms of a schedule, in terms of what will ultimately be a schedule, that would be really useful. I don't know if you want to talk about the format or anything to do with that. We're very happy to have a conversation about that. Generally, it's best to keep in my experience, a list of main modifications and a schedule of additional modifications. So, you know, just keeping those two lists separate so they don't blur. That's generally useful. And of course, there's, you know, given that we're doing St Albans, they've embarked on that process. I'm sure you've seen some of the work that they're doing. Yeah, and inevitably, as things progress, I mean, I can't, you know, there's a lot in there. So, you know, let us know when you when you're ready to get us a schedule of main modifications. Inevitably, there'll be some toing and froing in terms of the wording, and I wouldn't suggest doing that before anything to do with site visits or, you know, any implications that we'll need to reflect on from discussions. So don't rush on that, but yeah, if that's in hand, that would be brilliant. In terms of the various actions, I mean, fresh in my mind, yesterday we talked about a traveller note and a 5-year housing land supply note. I mean, given, you know, we do mean it, this sort of the intensity of a local plan examination and all the work that's going on in terms of main modifications and all the demands on your team, there's no rush in terms of those notes from our perspective, including as we need to go on site visits. We might, though, suggest the 24th of April for both, so that would be about a month from when it was discussed, if that, I'm seeing some nods. Okay.
That seems okay. You might have one just query just in relation to clarity on some of the requests, but just in terms of timescales, that seems appropriate.
Okay, great. And then, especially on the 5-year housing land supply note where the question was raised, will we get the opportunity to see it? In all likelihood, yes, we'll make provision for written representations on that, written submissions, if you like, and the logical time for that would be probably ending no later than the 12th of May. So just a sort of 2 weeks for any comments on that. That's how we see that working. I hope that sounds reasonable, to keep a bit of, keep a bit of momentum, but equally give people, including yourselves, time to prepare those notes and to think about them.
Yeah, that seems fine with us.
And yes, you said there were some points of clarity that you wanted to talk through. Those were the immediate administrative things that struck me. If there are any others, or if you want to talk about anything else, yeah, absolutely.
Before we start, I think on the clarity points, I just have a further, I remember we produced the Tring Sang kind of clarification note just to provide the emails. I remember you requested one for Berkhamsted too. I just provided the Tring note to the programme officer and that was published. So I don't know whether that would be the same for if the Berkhamsted note is ready earlier, if I send that on.
That's fine. I mean, in the case of Tring and also in the case of Berkhamsted, it was not that there was any new information. It was just pulling together, sort of making coherent the different bits of evidence. So that's absolutely fine. Yeah, same for Berkhamsted. So yes, do that. Please do that. Yeah. Come on, these are all easy questions. Come on, where are the hard questions? Where are the hard points?
So I think just on the point regarding, you make reference to the 5-year housing land supply. There's probably a few component pieces, I think, that were discussed around that. And I think it's just probably a little bit of clarity at our end. Yeah, so when it came to the note, one of the first points was the updated trajectory. I think first and foremost, there was a request for an updated trajectory to take account of the discussions. And I think that included commitments where I think we kind of mentioned, well, it's better that we get to the end of this financial year and we'll have a rounded picture of what has been permitted by the council or permitted in Dacorum in this financial year. And that we think that is sufficiently clear. When it comes to the detailed breakdown, I think there was a request as well about within the commitments and those permissions to provide a bit more detail on the bigger sites. Not so worried about the numbers relating to the smaller sites, it's how they fit within the trajectory. So we are going to look at that too. A third point is the allocations themselves, and Mr. Howell Williams yesterday made reference to the fact that you've provided feedback on the trajectory within the plan for a small number of sites. But I guess when it comes to updating our trajectory, it is probably in light of the discussion on, say, 2 or 3 sites, indeed where some of ours we've already responded to some of those maybe within our current trajectory. I think that the question is do we need to look at wider sites in light of that?
From my perspective, so there are certainly some, and then the one that jumps out is TRO2, which I think Mr. Birkinshaw mentioned. That I'm struggling. There is HM12, is it, which is plots 2 and 3, which comes out, which I think maybe has already been reflected. And there may be another couple. I mean, I signalled today that HM11, the timescale for delivery looks very tight. So thinking about those, taking what we've said, thinking about if there are any others reflecting on discussion that you would suggest the trajectory is amended, sort of giving it that critical sense check. But then, of course, it's essentially over to you to present us with what you think is the current state of play. We'll then review it. There's a lot going on in our minds in terms of what we've heard in terms of evidence, what would be irrational, and then we'll there'll likely be some toing and froing over that and the main modifications in time, especially in light of some site visits. So yes, focus on the ones where obviously we've given an indication. Do have a sense check if there are any others in light of discussions that you would seek to sort of change the trajectory on, and then we can have some toing on, have a sense check of that as we go through.
We will do that one more time. It's got to be taken in the context of, obviously, we've done a lot of recent addendums to statements of common ground, etc., and we've done a lot of work on that. So we'll just take it as being, we will look at each and every one just to ensure we're comfortable with our position on those relative to the discussion. I just wanted to be clear that, in light of that, we're just making sure that it's reflective and more broadly and not constrained or constricted to 2 or 3 specific sites.
That makes sense. And, and inevitably things change. If something's come in, if an intended submission of an application is delayed, if an application gets approved, absolutely fine to reflect that. We're not in the sort of section 78 inquiry territory where you have to be very careful in terms of, well, is this new evidence or whatnot. A local plan examination, because it goes for some time, if things change, do reflect in that, absolutely.
And just on a very point of detail, just because we don't want to end up, missing any areas, no stone unturned, as they say. If we are to make any changes that deviate from, say, positions that we have already set out through evidence, do we need to justify them clearly why we are changing them?
What is useful for us is, say, if you've got your schedule of main modifications, there's an explanation of where that originates from. So it could be as simple as, because the inspectors have asked for it, the hearing on the 4th of March. That could be the sort of the origin. If there is one that transpires that you want to propose that is different, say, to one that was in a hearing statement, because there's a new updated statement of common ground, it could be as simple as saying, to reflect the latest state of play in statement of common ground, DB ED 48A. So that's absolutely fine, so long as there's a sort of trail of, well, why is this here? Ultimately, when there's a schedule that goes out to, for consultation, for views, it won't have that. It won't have that section necessarily that says, where's the origin of this, but just so we know as a sort of an internal audit process, yes, absolutely, put in a little bit as to where that's come from. So.
Okay, thank you.
Cool.
I think that's sufficiently clear from our side. As I said, we'll just need to see the extent. I imagine initially the changes will likely be limited beyond probably what we've discussed, but we will just go through that sense check just to be clear. A final point, I think, from my side on the 5-year housing land supply, I think, which was a request, and just a point of clarity that to date we have been presenting much of our information in the context of a Liverpool approach, taking account of shortfalls. And I guess when it comes to what you are seeking in terms of detail on the 5-year housing land supply calculations, is just understanding what information you are seeking on that. Is it you are seeking Sedgefield, Liverpool, 20% buffers? and as I said, I don't want to limit the remit and give you something that perhaps isn't going to help you in your next steps. And I'm sorry if it's a very pedantic point of detail.
It's not a pedantic point of detail at all. In fact, it's a relatively important point, so it's good that you raised it. I think the first stage that we talked about is being absolutely clear in terms of the details of commitments, the trajectory for sites in light of discussions. Okay, and when you've got that, I think it would be really useful, and this is also what we did in St Albans, is if there are different permutations, and there seem to be 3, if I can say that. There's Liverpool, there's Sedgefield, there's no buffer, or there's 20% buffer. So, sorry, it would be Liverpool, Sedgefield, 20% buffer. If we can have those, so once you've done the sort of the hard work, which is looking at the allocations and commitments and those delivery trajectories, if you are able to present sort of those 3 scenarios, as I think you've done in brief in that table in your matter 11 hearing statement that I think, some people are like, well, where are the figures? And that's really what we're asking for, is the underpinning of those. If once you've got the sort of data, those 3 scenarios would be really useful for us to see as a sort of drawing from that evidence, if that's okay. Okay? Good. I'm looking around to see if there's any other administrative points. Anything else? Of course, if there are, it's useful to deal with them here, but if there are any administrative points, we can, we can deal with them subsequently. And okay.
Thank you. Just for clarity, there was, I think, a request for the justification informing the thresholds in policy H4 was sought as a note. So again, that was something, that was the 5% on sites of 40 dwellings or more. I think that was a custom and self-build point. And I just want to clarify that we will be looking at that as a note, but I think in the context of that should be based on the evidence we have, and it's not intended to present anything new. So in the context of
is this H4, sorry?
I believe so. It's the custom self-build, is it? Yes. So it's about that. I think there was, where's the, I think you need to do a note and look at the justification for why you have chosen those thresholds. We've already presented some information with our statements and we've talked about it. I guess the query is that something you are still seeking, firstly? And B, is that intended to be just a note as with the Berkhamsted sang, something that will just be published when we have it, or something that you might need to consider?
Well, in our view at this stage, it's the latter. It's a note that you produced. Now, there was, from memory, there's some ambiguity, wasn't there, in terms of the sort of evidential inputs, whether it's the self-build register, whether it was some other source of data, and how that led to threshold of 40 or more new houses, and how that led to the 5% in terms of aggregate supply of plots for self-build. So it would simply be the data that has informed that. How has that led to those thresholds? And it was also a slight invitation from memory, if you feel that those thresholds, in the light of discussion, because we heard in particular from the HBF, if you feel that those thresholds aren't justified, we're absolutely fine to look at, whether a different threshold, a different level, and a different percentage based on the evidence. So, yeah, but that, in our view, because ultimately, when we come to main modifications, there's the ability for people to comment in any event. What we need to ensure is that there's fairness for anything substantive that may inform the MMs to be commented on. This falls into the territory of, well, there was some complexity about the evidence that was there. So it's in a slightly different territory to the 5-year housing land supply work. So that would just be, it's a long way of saying that would just be a note. Yeah, okay.
Thank you.
Okay, great. Okay, brilliant. Well, thank you very much. Yeah, have a good rest over there. Well, I mean, if you get it, because there's lots of work ongoing. But no, genuinely, thank you very much. It's been very useful, and also thank you from Mr. Birkinshaw that's not here. We'll close then. Thank you very much.
Thank you very much,
Okay,
and thank you too for your time and the input as well, and for Mr. Birkinshaw also.
Good stuff. Thank you.
For Louise as the program officer too. We really do appreciate it. It's gone, without too much pause and hesitation.
Good stuff. Thank you very much. Okay, great.